welcome to Arbitration Acumen, a podcast from Bracewell's International Arbitration Group that connects in-house counsel and arbitration practitioners with industry experts, institutional insiders, and top arbitrators from around the globe to share their views on key issues in arbitration today. You can reach out to any of today's speakers by emailing arbitrationacumen@bracewell.com. And we hope you enjoy this episode of Arbitration Acumen.
Before we begin with our inaugural Arbitration Acumen episode, I want to personally thank you for tuning in and let you know that we mean what we say when we tell you it's your podcast. So if there's a topic you want covered or a guest you want to hear from, and that may be you, tell us and we'll do our best to make it happen. In short, please do reach out to us at arbitrationacumen@bracewell.com. That's arbitrationacumen@bracewell.com. with questions, comments, or suggestions so that we can make this the most useful and entertaining podcast we can. And with that said, enjoy the episode and enjoy Arbitration Acumen. Welcome back to the next episode of Arbitration Acumen, in which we'll discuss the SCC Arbitration Institute, colloquially called the SCC, with Caroline Falconer, who is the SCC's General Secretary, and Madeleine Thörn, who is the Deputy Secretary General. I'm JP Duffy. I'm an international arbitration partner at Bracewell based in New York that acts as both counsel and arbitrator in international arbitration seated around the world under a variety of governing laws and arbitration rules. And I'm qualified in New York, England and Wales, and the DIFC courts in Dubai, where I previously practiced. Caroline Falconer, who's our first guest today, is the Secretary General of the SCC Arbitration Institute, as I mentioned. She holds a Swedish LLM from Stockholm University and an LLM in International Dispute Resolution from King's College London. Caroline has over 10 years of experience in Swedish law firms, specializing in dispute resolution, and also has served at the Stockholm District Court. From 2015 to 2022, she worked as senior legal counsel at a leading European energy company, where she gained deep insights into the daily challenges faced by in-house legal teams. Caroline is a co-founder of SWAN, the Swedish Women's Arbitration Network, a professional network dedicated to women in arbitration. She's also chaired the board of the Swedish Company Lawyers Association and serves on the jury for the prestigious, quote, Company Lawyer of the Year award in Sweden. Additionally, Caroline is a council member of the International Federation of Commercial Arbitration Institutions, the IFCAI, and a board member of the International Law Association, Sweden. She's a frequent speaker at both domestic and international legal events. So that is a handful or a slew of accolades there. So we're looking forward to hearing from Caroline. Also with us today is Madeleine Thörn, our second guest. Madeleine is Deputy Secretary General and Head of Operations at SCC, and she leads the operational team responsible for administering approximately 200 cases annually, involving commercial and investment disputes with parties from around 40 jurisdictions. Madeleine is actively engaged in several arbitration organizations. She serves as a member of the Stockholm International Hearing Center Advisory Board, is a member of the institution's task force for the Campaign for Greener Arbitrations, and is part of the nomination committee for the Young Arbitrator Sweden. Madeleine is frequently engaged as a speaker to share her views of the latest trends in international arbitration. Prior to joining SCC, Madeleine was a practicing lawyer and associate at both a law firm specializing in dispute resolution and an international law firm in Stockholm, Sweden. Her work focused on domestic and international arbitration, as well as commercial court disputes, spanning various industries and legal areas. Earlier in her career, Madeleine served as a drafting law clerk at the Supreme Court of Sweden and as a law clerk at Solna District Court in Stockholm. So, as you can tell, we have great guests today that can offer a wealth of knowledge about the SCC. But before we hear about that, I want to hear some very short background information about the SCC for those audience members around the world that might be less familiar. And I'm going to turn to Caroline for that. So, Caroline, welcome.
Great. Thank you so much, JP. And thank you for the invitation as well. We're very happy to be here. So I'm the Secretary General of the SCC, as you already said, and it's quite a position, I must say. The SCC has been around for quite some time. We were founded in 1917. We are part of the Stockholm Chamber of Commerce. were founded by the Stockholm Chamber of Commerce. And in the beginning, we were only a member benefit. So we were only open to Swedish companies in members to the Stockholm Chamber of Commerce. But we scrapped that rule a number of years ago, of course, because in the 70s, we saw that we were becoming an international player for commercial arbitrations mainly. So in the 70s, we adopted our new rules set up for international arbitrations. We also were included in an optional clause agreement, a cooperation agreement, you can say, between the US and the USSR, the Soviet Union. And that is quite an accomplishment, I must say, for Sweden back in those days, because that led to very many international disputes being located to Sweden or seated in Sweden from the 1970s and onwards. We still see a number of disputes between the East and the West. Nowadays, a lot of Russian disputes coming to Sweden, but also other countries within the CIS region. In the 80s, after having this position between the East and the West, Russian disputes from the mid-70s, then in the beginning of the 80s, we were included in a trade agreement or a cooperation agreement with China, the China Council for Promotion of International Trade. And that led to a number of Chinese parties and commercial disputes with Chinese companies being settled in Sweden. So, and that is also something we still see today. So we still see the CIS region and China quite a lot in our disputes. But our region grew even more in the 80s and the 90s. And nowadays we see more than 100, well, not 100, but more than 93 different countries in the last 10 years and approximately 40 to 45 countries every year in our arbitration. So we have our region is much larger than what it was in the 70s and the 80s. Something else that was quite important in our history was in the beginning of the 90s and the 80s, a lot of investment protection treaties were signed, were concluded between states in those years, and a lot of them referred to the SCC and to Stockholm as well. So we have since 1993, we have seen a quite large number of investment arbitrations being resolved at the SCC. And we are also one of the appointing authorities listed in the Energy Charter Treaty and have handled a number of those arbitrations since the 90s. And this is something we're quite proud of. Of course, there are not that many institutions in the world handling investment arbitrations in this way. So one way of giving additional transparency to these arbitrations at the SCC has been to publish a new report on investment arbitrations. It's called Arbitrating for Peace, and you find it on our website if you're interested. But if we started out as very much a good gateway to between the East and the West, we now have seen the Swedish heritage quite a lot at this institute, because we are trying to be very innovative. Well, Sweden is known to be early adopters when it comes to new technology. We stand behind quite a lot, a number of large Swedish companies in the world driving change and driving innovation. And we would like to have that Swedish tradition go through this SCC as well. So something we did quite early on was to digitalize our case administration. We have our platform, the SCC platform, and a platform for ad hoc arbitrations as well, the ad hoc arbitration platform. So we are digital. We are looking into ways to make arbitration much more cost efficient and modern and give the parties a modern feeling to their dispute resolution, while still keeping a very high quality to it as well. So maybe that was a very, very short background and very short introduction to the SCC, JP.
No, it's a really valuable one, because I think the SCC occupies a really unique position within the arbitral world, as you highlighted, particularly with that historic connection between the USSR and the US and the agreement signed between what was really, I guess, the AAA in America and the Soviet Chamber of Commerce. And then the same with China. Really interesting, and particularly on the investor estate front as well, which is a very, very unique thing for an arbitral institution. Now, you mentioned a lot of really interesting statistics. I want to drill down on those a bit with Madeleine. So Madeleine, welcome. Thank you for joining today.
Thank you for having us.
Yeah, of course. Maybe you could give us a little bit more on how many cases SCC administered in 2024.
Happy to. So we had a really, really good year last year, and we are having a steady increase also this year. And we have seen a steady increase over the past years, really. So if we go back, if I pause for a bit with the number of cases for 2024 and start with 2022, we had 143. And then going to 2023, we had 175. So a steady increase there. But then last year in 2024, we had 204 cases, so more than 200 cases. And we're really happy about that. And we see that the number of cases that we have now are very impressive as well. So we are very hopeful to see how many cases we will end up with in 2025. Similarly to the increase in number of cases, I can add that we've also had an impressive increase in the disputed amount. So similarly, we have had about 1.6 billion euros in total disputed amount in 2022, then increased, almost doubled in 2023 to 3 billion euros in total. But then last year we had 13.5 billion euros in total in the disputed amount, which I think is worth mentioning as well.
Wow, that's very, very impressive growth. And Madeleine, what do you attribute that to?
Well, we see that we've been working very hard with focusing on the development that Caroline mentioned, with being a modern institute, being mindful of our digital services. Already back in 2013, we implemented a digital case management system. And since then, we've been working very hard to have the newest technology, how we can assist the best way to work in a really resource mindful manner, but then also to assist our parties and to be really what is expected of us in today's society. And we're always looking ahead to see how can we be even better for the needs of the companies and industries going forward.
That is certainly something that companies should pay attention to, because that level of efficiency is really critical. It's one of the key features of arbitration and why a company wants to use it. Now, out of those cases, Madeleine, what percentage approximately were international?
So last year we had 51% international cases out of the 204. And by international, when we publish our statistics, which is available on our website, we mean at least one party from another country than Sweden. But we can also say that the majority of those 51%, they are truly international, meaning no Swedish party at all. Many times we have no connection to Sweden apart from the SCC administering the case. So we can have a governing law being another law, and there can be another language in which the case is administered, and arbitrators and parties from any other country in the world, really.
That's really impressive. And are there particular industries that those cases are coming from, or what are some of the ones that are more represented?
We see a wide range of industries at the SCC, from retail consumer products to financial services, real estate and construction. We see technology and energy. And over the past years, we have seen an increase in cases concerning renewable energy, such as wind parks, etc., and disputes concerning the green transition.
That raises a question for me as well, because the timing of the case increase is interesting in terms of geopolitical events and events between the East and the West. What countries were the top 5 users of SCC in 2024?
So in 2024, we had in total 488 parties from 40 different countries. And the top 5 nationalities were, apart from Sweden, Russia, UK, Norway, and Finland. But I can also add to that we had a very international pool of arbitrators. So our arbitrators in 2024, they came from 26 different countries on 3 different continents, including the US, UK, Singapore, China, Russia, Costa Rica, Hong Kong, and Serbia, and Sweden, of course.
That's quite a list. Did you see an increase in the use of, or an increase in the number of cases involving Russian parties, given what was going on in the world?
We have seen over many years that we do have that Russia is usually on the list of the parties that we see at the SCC, and we sometimes also administer cases in Russian.
Interesting. Well, that raises another question for me. Just out of curiosity, what percentage of cases that the SCC is administering are conducted in English every year?
So we have a majority of our cases are conducted in English, and we also see Swedish, of course. But in addition to that, we also see Russian and French every year. But it's been around 50% and above 50% over the past years. And last year it was 51% in 2024.
That makes sense. And what percentage of the cases, if you know off the top of your head, involve some energy component? Bracewell's a pretty large energy firm, so we're always interested to know about the energy sector. So I'd love to know how often the SCC is seeing energy cases.
We see a lot of energy cases, and energy, that is about perhaps 15% around that.
Wow. Okay. And is that across the energy sector? Is it oil and gas predominantly, or is it wind? Is it something else, renewables?
It can be renewables as well. So that can be different types of energy disputes.
Interesting. Well, given that, are there particular market segments that SCC is targeting for international cases, or something that it views itself as particularly expert in?
Well, we're open to all cases, and we see, as I mentioned when talking about the industries, a wide variety. So we see that many different companies and industries are interested in resolving their disputes at the SCC, and also that we have lots of different types of contracts, both short-term and long-term. And that's why we also provide different types of dispute resolution services. Apart from our SCC arbitration rules, we have the expedited rules, which I know we will talk about, and also other types of services for shorter, where you can have dispute resolution in shorter time and also for a lower fee. So that said, that works really well for different types of sectors and market segments. But to mention a few examples where we do see extremely large and complex international cases, they concern mainly energy that we've been talking about, but also technology and financial services.
Interesting. Yeah. Well, I've certainly represented some very large Swedish telecommunications companies and other tech companies. So I know that's a very significant sector, and not surprising that financial services are an important sector as well. Well, you mentioned the rules, Madeleine. Let's transition a bit and talk about some of those, because the SCC issued new arbitration rules in 2023, if I'm correct.
That's right.
Well, that's great. What are some of the salient features of those rules?
So when we updated our rules in 2023, it was really in response to the COVID pandemic, where we had seen that there had been questions about the mandate of the arbitral tribunal. And for us, it's very important to have an efficient case management and for the case to move forward. And there were some questions about whether or not there could be virtual hearings when not all parties were in agreement about a virtual hearing, which could be essential in order for the case to move forward, especially during COVID, when you didn't know when or if you would be able to get back together in person. So we clarify that in the rules. And I would say that this is the one thing that I would like to highlight about the rules revision in 2023, that we explicitly stated that it's within the mandate of the arbitral tribunal to decide whether the oral hearing should be in virtual format, in person, or in hybrid format. And I think this is really stressing the emphasis that the SCC places on efficient case management.
Madeleine, you mentioned earlier the expedited rules. Tell us a bit about that.
Happy to. We're proud of our expedited rules, and we see an increase in use of them, and we think that they can really help to keep down costs and time when it comes to dispute resolution. So what differs when you use the expedited rules compared to the SCC arbitration rules is that you have one arbitrator. There's always one in the expedited rules compared to the SCC arbitration rules, where you can have one or three arbitrators. But we also have a front-loaded process where everything should be stated as much as you can in the first submission. That is to say that the request for arbitration is also the statement of claim, and the answer will also be the statement of defense. In this way, we can keep the period of time for the process to shorter than it would otherwise be. And according to the rules, the award should be rendered within 3 months. And we see that in practice, the award is rendered at least within 6 months. So it's a very swift process if you compare internationally. And then you will have an award that is enforceable, and it will be done in short time. But then again, the parties may have an oral hearing, and they will have, of course, all the rights to be heard so that the case is treated in the way that it should. I can also mention that we don't have a monetary threshold for using the expedited rules, but for us, party autonomy is the essence and is essential. And that's why it's always up to the parties to choose whether they want to use the expedited or the arbitration rules. So we don't decide, and there is no mandatory provision when it comes to using one set of rules or the others, but it's always up to the parties. But one thing that we do recommend the parties to consider when drafting their arbitration clause is to include a combination clause, which then states that in the first hand, you can use the expedited rules, but then depending on either the monetary value of the case or including other circumstances, it can be that the SCC decides to use the arbitration rules instead, which then allows for flexibility to consider the actual dispute at hand. Should it be the expedited rules or the arbitration rules? Because many times when you negotiate a contract, you're not aware of what kind of disputes that can arise. Will they be complex? Will they concern a large amount of money or a smaller amount? And what is a better fit? So we usually recommend the parties to consider including a combination clause in the contracts.
So unlike something like the ICC rules, where if it's below a certain monetary amount, there's no obligation, even for small disputes, to use the expedited rules. It's up to the parties to choose them.
Correct.
Now, let's say, just for the benefit of the audience, let's say you have a situation where the parties haven't considered that, and unfortunately that does come up probably more often than it should, but they haven't considered that. They've just drafted a standard SCC clause. How would that possibility of using the expedited rules get introduced to the parties in that instance?
Of course, we are very open to using the expedited rules instead, provided that there is an agreement between the parties. So we are flexible in that sense, and we're always available and transparent when it comes to our processes and our rules. So we have a communication about that. But then again, given the flexibility of our arbitration rules, where you can have 1 or 3 arbitrators, I think that can also work really well for even smaller cases.
So the SCC would raise that with the parties at the outset?
Well, we do. We don't raise it with the SCC arbitration rules because, as I mentioned, they are flexible enough to work really well, both for smaller and bigger cases. What we do raise is if they have a clause referring to the expedited rules, but we see, and it can also be up to the arbitrator later on, but if we see that we think it could be worth considering the SCC arbitration rules to allow for more time and more submissions, then we will raise that with the parties. So say rather the other way around, I will raise that question with the parties.
Now, the 2023 rules also have the SCC Express Rules, correct?
We have a separate set of rules that are the SCC Express Rules. That's correct. And they're also from 2023. And we're really, well, actually they were updated then, but they were launched in 2021. And we're really proud of the SCC Express Rules, because that really provides for a new way of resolving disputes. And I'm happy to go into a bit in detail if you would like me to.
Yeah, let's talk about those a bit, because I believe they would sort of be characterized as emergency arbitration rules that are becoming more common under most arbitral rules. I've sat as an emergency arbitrator several times. I think and I've certainly done them as counsel as well. It's a really interesting process that has really changed the face of arbitration in a lot of ways. So I think I'd love to hear, and the audience would love to hear more about the Express Rules and how they work.
Happy to. And I'm also happy to expand a bit on that, because we do have a separate set of rules when it comes to the emergency arbitrator that we also offer. That is included in the SCC Arbitration Rules and the SCC Expedited Rules. So if you have agreed on either of those 2 set of rules, you will have access to an emergency arbitrator. And under the SCC rules, we appoint an emergency arbitrator within 24 hours, and the decision is to be rendered within 5 days. So it's definitely for emergencies, and we're very swift in our handling. And I dare say that we are faster than some other institutes in this instance. And we're very proud of this. And of course, it's a proof of our dedication to arbitration as well, that we do appoint an emergency arbitrator within 24 hours, regardless of Friday afternoons, the day before Christmas, and so on. So this is definitely something that we provide to the parties if they choose the SCC Arbitration Rules or the SCC Expedited Rules. But we have also launched another service, another way of resolving disputes, which is the SCC Express Rules. And that's a separate set of rules. And you have there a fixed fee. In the other rules, in the SCC Arbitration Rules and the SCC Expedited Rules, we have an ad valorem system. So based on the disputed amount, we will then have intervals of a range of how much the fees will be for the arbitrators and the SCC administration fee. All this is available on our website through our cost calculator. But for the SCC Express Rules, we have a fixed fee of 29,000 euros, and that includes the fee to what we call the neutral expert, the legal expert that will decide the case, and the SCC administrative fee. So the neutral expert, legal expert, has 3 weeks to decide a case, and this is perfect for ongoing relationships where perhaps a binding decision is not necessary, enforcement is not necessary, but it is necessary to have an indication of the legal framework and to get a legal decision on what to do or how to interpret a certain clause in a contract, etc. Many times we can see that you can reach a settlement after you have a decision from the SCC Express. And there are also different ways of handling. For example, if it should be binding, the default is that it's not binding, but you can, of course, agree that it should be contractually binding. And you can also appoint a neutral to be an arbitrator and then confirm the decision in an arbitral award. So you have all three possibilities when it comes to enforcement. And this is very flexible and something that we have heard from the parties and also seen in practice that they appreciate the flexibility and a way to maintain an ongoing relationship.
Wow, that's really fascinating. So it's really separate and apart from emergency arbitration. It is a bit of a hybrid, it sounds like, between arbitration and somewhat, I wouldn't say mediation, but giving an indication as to how an arbitrator might view the award or might view the dispute. And then it could be binding if you choose to make it so.
Exactly. And it's really a fast and cost efficient way of handling your dispute. And if you have a very specific issue that you're not agreeing on, that's perfect. And it can be resolved within 3 weeks. It can also be used in an ongoing project, for example, construction project, where you need decisions to be made throughout the project and the construction. And that can really be of great help so that you don't gather up all the different issues in the constructions that you may have to the very end, but you can resolve it as you go along.
So almost acting like a disputes board along the way to help get things resolved and keep projects moving.
That can be a comparison, yes.
That's great. Well, that's for those in the audience that practice in the life sciences space, that's a real plug to consider, because that is again, an industry in which there are long-term commercialization and development projects. Disputes can arise along the way. It sounds like that would be a really ideal mechanism for that industry. So something to consider.
If I may add, we've also seen it used within company groups. So if you have a dispute between two subsidiaries, this is a way to resolve it if it's not possible to resolve it within the group itself. But that was not the plan when we launched these rules, but we've seen it being used that way.
Oh, that's a really interesting byproduct of that process. I wouldn't have thought of that, but yeah, that makes a lot of sense. Fascinating. Well, Caroline, let me turn to you then just to talk a bit about the SCC Arbitrator Registry, because I think it would be helpful for the audience to understand that. So tell me a bit about the SCC Arbitrator Registry, how big it is, how do you get to be on it, how does that all work? It's always a topic of interest.
Yes, I know. One of the frequently asked questions, of course. So the SCC, we appoint one of our most important decisions is, of course, to appoint the arbitrator for the case. And we appoint approximately 250 arbitrators every year. And 35-40% of them are being appointed by the SCC board. And those appointments are mainly done for sole arbitrators or chairpersons of tribunals. But when we do those appointments by the board, we always have a look at our own lists, of course. We are not restricted by any list. We have this SCC Arbitrator Registry. It's free to apply to it and to be in on it. So please upload your details. You find it on the website. You can go to the sccarbitrationinstitute.com and you find the SCC arbitrators there. But we do look at the list, of course. We do also look at previous appointments, previous arbitrators we have experience with, but also our own training programs. We have a number of training programs, both for international arbitrators in English and for Swedish-speaking arbitrators. So we aim for finding the most suitable arbitrator for the case, whether that is someone from China or from Egypt or the US or the Nordic region.
Interesting. Okay, well, that's great to know. And I will certainly be looking at that myself. Well, this has been really helpful. Let me pivot a bit and talk about the future, because I think it's clearly a bright one for the SCC. So, Caroline, if there's one thing, and we're halfway through the year now, we're getting actually closer probably to the second half of the year than the first half. So if there's one thing you'd like to see SCC accomplish for the remainder of 2025, what would that be?
So we are already quite well known for our cost efficiency. We have the same high quality as the other large international arbitration institutes, but we do things in a more swift way. And that is something that is my main goal for this year, is to keep that cost efficiency and to keep that high quality. We are now, as many others, looking into AI and different possibilities. How can you make this even more efficient, even more cost efficient, and even with an even higher quality, if that is possible? So this is something that is the goal for this year.
What about in the next 5 years? Where would you like to see the SCC in 2030?
So in 5 years, we would love to see an even bigger SCC, to see this growth we are seeing in the last couple of years continue. And that is not only because we would like to become bigger, because we think we are offering the best service in the market, because we are not here to make any profit. We are a non-profit organization. But our goal is to really support international trade. And by supporting international trade, we believe that we are supporting international peace as well. And that is something we would like to see more of in the world we are living in today. So we are looking at different ways to come out with our offer in an even more efficient way. How to get businesses in different countries to enter into contracts, to dare trust each other, and to make business again. So that is the long-term goal for us, to grow international business and international trade.
Well, I have to say, if one of your objectives is to continue the growth trajectory, you're well on your way, because that caseload growth is very, very impressive. The growth that Madeleine mentioned earlier is certainly indicative of a bright future. Well, I think then that concludes our present discussion of the SCC. I think there'll be more to discuss in the future again, because I'd love to have you both back. But in the meantime, I want to thank our guests, Caroline Falconer and Madeleine Thörn of the SCC, for their invaluable insights. And I want to thank you, the audience, for listening. You should feel free to reach out about today's podcast with any questions you might have to either Caroline or Madeleine or me. We look forward to having you tune in for future episodes in the Arbitration Acumen series. And we're definitely looking forward to having Caroline and Madeleine back at some point to hear how the plan for the 5-year growth has been executing. So thank you both.
Thank you.
Thank you very much.
Thank you for listening to this episode of Arbitration Acumen. We hope you found it insightful and informative, and we encourage you to share it with your colleagues if you did. You can reach out to any of our speakers by contacting them directly or by emailing arbitrationacumen@bracewell.com. We welcome any questions or suggestions you might have for future episodes. And please subscribe to our podcast channel to stay up to date with our latest content.